You're filming people.
I'm not filming. I'm not filming them people at all.
I've just stood watching you.
No, I was changing the battery.
Right. Okay. Well, I'm not going to dispute that, but you were stood by a fence line observing people. Have you got a ticket for the match?
For your own sake, in future, if you have press as well, because it's quite a common question for press that we would ask.
You're just using every trick in the book. You want to do this, don't you? Go on, come on, go and do it.
Your name and address.
Go on, do it. Come on.
I don't want to search you. I'm asking for your name and address.
Why do you want my name and address?
Like I've said.
Under what provision do you want my address? Just make it clear to me.
Based on the current counter-terrorism threat.
Yep.
You've been with this group of people all day. You're now on private property.
Yep.
You've disputed the fact that you're filming on private property. It's a massive football fixture. 54,000 people are going to be present. You've not got a ticket.
A camera
on private land.
A camera isn't a device of terrorist purposes.
And you're acting suspiciously.
I'm not. You're just using every trick in the book. You know what you're doing. Yeah. I know what you're doing. It's cool.
I'm not going any.
Welcome back to the channel, because today's footage is a masterclass in how authority collapses when it isn't backed by knowledge. What you're about to see isn't just an uncomfortable police encounter. It's a slow-motion legal car crash unfolding in real time. An auditor with a camera, a major football match, heightened emotions, and an officer who reaches straight for one of the most serious pieces of legislation on the books, counterterrorism powers, without fully understanding how or why they apply. This encounter starts small, but it escalates fast.
Enforce it, sir, just to make it clear. No, what provision?
Like I've explained.
What provision? What section of what?
Under the counter-terrorism law.
Which section?
I'm obliged to ask for your name and address.
Yeah, but which section?
Which section?
Yeah, I need to know for my personal records, because I keep personal records.
That's fine. I'll refer to my pocket notebook and I'll give you a full legislation hit. But whilst we're doing that, you give me your name and address.
But you've got access to P&L.
Obviously, this is a football fiction. And we're on behalf of the club.
You want to do the thing? I'll comply with you. I'm going in a minute anyway, dude.
You're going nowhere at the moment. Okay, you're detained.
Am I detained?
Confirm your name and address.
Under what section am I detained?
I'm going to confirm that shortly. Okay.
Shortly, because
under the counter-terrorism legislation, you've been acting suspiciously all day around a large group of people.
You know I haven't.
Right here is where the encounter fundamentally derails. The officer jumps from observation straight into counterterrorism, and that leap matters. Section 43 of the Terrorism Act 2000 is not a casual power. It requires reasonable suspicion that a person is a terrorist, not just that they look out of place or are holding a camera. Filming, observing, or standing near a fence line simply does not meet that threshold. Notice how private property is introduced as justification. That's another red flag. Trespass in the UK is overwhelmingly a civil issue, not a criminal.
Because you don't like me being here.
I've got body-worn footage of you all day
have I.
In the city centre.
So have I.
Which concerns me slightly.
Why is it concerning?
Because I'm lawfully obliged to take my video capture. You've said you press, you've got no press badge.
What do you want, my name and address, yeah?
You're lovely, yeah. Driving licence, any ID.
Just to... And
can you confirm which press agency you're working for, or you freelance?
Just to... which section am I providing these to you?
I will give you the section, like I've said. At the minute,
I'm detained without a section, I'm just detained?
Yes, you are, yeah.
Are you sure?
Yes, I am sure.
What's your calling number for me?
There's my calling number.
18241. Cheers, brother. There you go.
I appreciate that.
No worries.
In 20 years of policing, mate.
You've messed up, not me, mate. You know this, and your colleague knows as well.
I disagree entirely.
No, your colleague knows as well, so he's laughing.
I disagree entirely, mate.
I know, dude. I know. Don't worry about it.
That's fine.
We all make mistakes, my friend. It's section 43, I think.
Well, it's very kind of you to try and reference that.
This moment is devastating from a legal standpoint. The auditor asks the most basic, fundamental question any detained person is entitled to ask. Under what section am I detained? And the officer doesn't know. That alone is a serious problem. If an officer deprives someone of their liberty, they must already know the power they're relying on, not figure it out later. Pulling out a phone to consult the police national legal database after detaining, someone flips the legal process completely upside down.
Are you registered at this address? Because it's an offence not to have the correct address on your driving licence. Are you registered at that address?
It's an offence to drive with it, but...
it's an offence to have the wrong address on your driving licence.
What do you mean, registered at the address?
Basically, do you
live at that address?
Yeah, sometimes. You know, mate, you know.
I'm not going to take on any further, but you know what you're doing.
I know, I do.
What I will confirm with Manchester City is they're going to get your photo on their club cameras as well.
I don't
before we
care.
finish.
I don't follow football. It's for these kind of people. I don't follow football. Don't follow football. Not remotely interested. Honestly. Do your worst. Tell the SAS.
It's frozen, so you have to bear with me for the moment, okay?
So am I detained under section 4?
Now we see the real objective emerge: identification. In the UK, there is no general obligation to carry or produce ID. Unless you're driving, under arrest, or being reported for a specific offense like antisocial behavior under Section 50. The police cannot simply demand your name and address because they want it. The officer begins fishing, using phrases like acting suspiciously, as if suspicion alone is a crime. It isn't. Suspicion must be tied to a specific offense, not a general feeling. Terror legislation cannot be used as a shortcut to gather personal details for a database.
You've referenced that. I've not given you my full grounds, but what I have told you is I've got enough grounds currently, based on your actions today and the evidence on my body-worn video, to suggest you're up to no good.
To suggest I'm up to no good?
If you've provided the fact that you're filming for a company and you've got permission
I'm not filming
to
for
be
a
here,
company.
You said you remember the press.
I'm freelance press. Anyone could be press. You can be press.
Yes, if you have a badge and ID.
No. You can consider yourself press. You can take photos. Freelance.
I've spoken to many freelance press officers before, and they all have ID.
We're not required to carry identification in the UK. We are not required to carry any ID in the UK, whether we are a banker, a press photographer, or a footballer. You don't need to carry any ID. I promise you, sir.
I'm still frozen.
No worries.
So we're still here. Okay.
Still detained indefinitely.
Well,
with no section.
Details.
You can write it down. No problem.
Here's a widespread myth being exposed in real time: the idea that press requires official credentials. It doesn't. The UK has no state-licensed journalists. Freelancers, independent photographers, and citizen journalists are all legally valid. A badge is convenient, not compulsory. The officer's insistence on press ID shows a misunderstanding of media law. Even more concerning is the photographing of a detained individual who hasn't been arrested. While police can gather intelligence, photographing someone without arrest under these circumstances raises serious privacy questions, especially when the ground for detention remain unclear.
Here we go, we're on. System's working.
So
what we'll do also, I'm going to fill in an intelligence submission when I go back to the station, okay? Detailing this stop and why we've done it, okay?
as you're required to do.
Yes.
Shame you didn't do one of these against Salman Abedi.
Again, it's really...
Nothing to do with you. Nothing. I get it.
If that's how you feel, mate, that's how you feel.
No worries.
It's okay.
You know I'm not a terrorist. I know I'm not a terrorist. She knows I'm not a terrorist. He knows I'm not a terrorist because he's seen me all day filming football fans and he knows I'm press.
I know you're not up to no good, mate.
You know I'm up to no good. You know for a fact.
Yeah, you're trying to mouth off and one about the Manchester bomb and be disrespectful to what I do.
What?
I've just
what
told
am I
you.
doing that's up to no good?
You're filming in a private area, large groups of public, entering an iconic site.
You're
within
allowed
Manchester.
to access this until you're asked to leave.
Right.
Trespass is a civil matter. It's not illegal.
Yeah. You're trying to question every ground I've
Of
given
course
you.
I am, because I have civil rights, and the second I give them up, I'll lose them. You're the one being unlawful here, not me. This is an unlawful...
This statement is chilling. I'm going to fill in an intelligence submission because it reveals the real purpose of the stop. This was never about an imminent terrorist threat. It was about data harvesting. Section 43 cannot be used simply to populate intelligence reports. That's explicitly unlawful. If this officer truly believed the auditor was a terrorist, this interaction would look very different. There would be control of hands, immediate search, backup requested. Instead, the auditor is casually holding a camera while the officer debates policy.
Section, all the provision.
This is a stop and account.
Yeah.
Have I laid a finger on you?
You've detained me.
Have I laid a finger on you?
That is an assault because you've detained me unlawfully. You know it's an assault. You don't have to touch someone for an assault. You know that. You're a cop. You know that. This is an unlawful stop search. £500 per hour, sir. You know.
That's an opinion from yourself.
No, it's fact, case law. I've done it a few times.
Very well.
Don't worry, it's going on. Don't worry.
You'll notice that's not speeding up my process. I'm doing my job now, okay?
Don't worry, dude. If it goes over an hour, it'll be it's easy.
Yeah.
You know what unlawful detention looks like. You know what it looks like.
Mate, I understand my powers, I understand my grounds, okay?
You haven't given reasonable grounds for a terrorist search. Well, you haven't given any grounds.
I've told you what
you just said suspicion.
What's your current address? We've got 2 addresses on the system for you.
What address have you got, and I'll confirm it?
We've got this one, and we've got an address.
Just put that one.
That one? Okay. So you're living there at the moment?
Sometimes, yeah. I'm a vulnerable adult with mental health conditions. I live at separate addresses and I'm under the care of separate people.
Okay. What mental health conditions have you got?
Paranoid schizophrenia.
Right. Do you wish to share how you're feeling at the moment?
Fine.
Need any support? Do you need any support?
No.
Okay.
I'm on medication. Yeah. I'm under a mental health
team. Have you got a casework? Have you got a care work?
Yep.
Do you need me to speak to them at all?
No.
You sure?
Absolutely fine.
Okay.
I was
based on what you've said
now.
Based on what you've said.
Yep.
I've got a duty of care to make sure that you either get home safe or I speak to a care worker to confirm.
I'm trying to get home. I was just going over, just as you approached me.
Are you with the chap on the bike?
Just as you approached me,
right,
yeah.
okay.
I wouldn't like you to disclose any of my personal medical information to him.
Invoking the Manchester bombing is emotionally powerful, but legally irrelevant. Tragedy cannot suspend civil liberties. Courts don't rule on fear. They rule on facts and law. Using past attacks to justify present overreach is an emotional argument, not a lawful one that the officer also slips into acting as private security for the football club, enforcing policy instead of law. That's not policing. And being disrespectful, sarcastic, or challenging authority is not a crime in the UK. This is the heart of the conflict. One side insists on legal clarity. The other relies on authority and expectation of compliance.
No, you're going
changing the battery and going home until you unlawfully detain me.
That's your opinion?
I know it is.
Okay.
Yeah. We're not going to get any further.
To go home with.
I'm perfectly able to go home. Promise you. Promise you that.
Right, thank you very much. I'm going to ask you to leave the area now, okay?
Sorry?
I'm going to ask you to leave the area to the gate, and then that's public land.
I'm going home anyway. That was my plan. Just as I was changing the battery, I was going home.
If you'd have said that as we'd have spoken to you, perhaps things would have been differently.
I did.
This case boils down to one uncomfortable truth. Power was used first, and justification came later. The officer never clearly articulated lawful grounds before detention. Counterterrorism legislation was invoked without reasonable suspicion. Identification was demanded without legal obligation. And intelligence gathering appeared to be the real objective all along. While the officer eventually softened his tone, especially when mental health was disclosed, tone does not erase earlier failures. Lawful policing requires clarity, necessity, and proportionality from the very beginning.